You're listening to the B&H Photography Podcast. For over 40 years, B&H has been the professional source for photography, video, audio, and more. For your favorite gear, news, and reviews, visit us at bnh.com or download the B&H app to your iPhone or Android device. Now here's your host, Alan Weitz.
Greetings and welcome to the B&H Photography Podcast. David Deal is the founder of and principal attorney at the law office of David C. Deal, PLC, located in Charlottesville, Virginia. He is a nationally recognized intellectual property attorney specializing in copyright infringement matters on behalf of photographers and businesses. David has successfully litigated cases of all sizes and complexities in a majority of federal jurisdictions. Recently, David successfully represented photographer Russell Brammer in his appeal of a federal court's ruling that a nonprofit film festival that used one of his photos they found on Flickr had not violated copyright by using a cropped version of that very same photograph. David is also a photographer in his own right. In 2001, Alter Books published Prospects, a portrait of minor league baseball, a collection of David's photographs and short essays on minor league baseball. His fine art photographs are included in the permanent collections of major museums and private collectors in the United States. We're going to talk to David about the Brammer case and also try to clarify a few legal questions that we have. Welcome to the show, David.
Thank you very much.
It's great having you here. Let's start talking about this Brammer versus Violent Use Productions case. Give us the background of that. What happened?
The case is actually, the facts of the case are actually quite simple. And Mr. Brammer is a 20-something-year-old photographer just starting out. He took a very nice, well-composed, well-thought-out photograph of a cityscape. And the defendant in the case, Violent Hughes Productions, who runs the Northern Virginia Film Festival, decided to use Mr. Brammer's photograph as well as a number of other photographs on a page depicting places that filmmakers and guests to the film festival might visit while they were in Northern Virginia or Washington, D.C. And obviously, it didn't sit well with my client. And when we contacted the film festival, they refused any kind of negotiation and refused any kind of compensation. So through really a kind of a quirk, it ended up landing with a certain judge in the Eastern District of Virginia who, at least from my perspective, didn't want to dedicate too much time to the real legal matters and dismiss the case based upon the defendant's assertion of fair use. And that's how it ended up with.
And is that because the judge really didn't understand the rules of copyright law?
We don't know. The opinion was remarkably, for such a what can be a complex and nuanced legal issue, fair use, it was a 3-page opinion. And that's covering 4 distinct elements of fair use as defined by the Supreme Court. So it was short and sweet. You know, if I were to guess, I think the judge wanted to get rid of it. But with that, we were given an opportunity. And the opportunity was we were unwilling to live by the judge's decision, and we appealed it to the Fourth Circuit. And that gave us a chance to fully argue it in both brief form as well as oral arguments before the judges.
Now, do you think one of the reasons why the judge might have just blown it off, for lack of better words, is because the photograph that was used wasn't represented as that this is my photograph, I took this photograph, nor was it really being used for any kind of monetary gain, really. It was used as an illustration, as a guide for people visiting this festival. So it's kind of like twice removed.
Right.
Do you think that might have had any bearing on it?
Yes. And the bigger picture is, I mean, the reason why this case is so, I would stop short in calling it important, but ultimately the circuit court ruling and the overturn, the decision to overturn the district court's decision is important because there's been, even in my relatively short period of practicing copyright law, and limited to photographers, there has been this slow, constant, steady creep toward the opinion of that judge. And that is, well, and I'm summarizing kind of everything that I hear on a daily basis, but we didn't really use it we didn't really gain anything from it. We didn't put it on t-shirts and we didn't put it on mugs, and we're not gaining directly from that image. And, if anything, we helped your client, by, and these are, I hear variations of these same.
Was
10,
the photographer's name, did it appear anywhere in that brochure? Was there a credit given to any of these photographs? Because they say we're giving the photographer.
Yeah, by the defendant, no. And in this case, it's a little bit different, but the argument by the defendant in this case is something that I hear on a daily basis, which is, well, we didn't really know. It's so complicated. The internet is so complicated. All we did, we performed a Google search. We found this image, and look at us. We're really small. It's no one's seen this page, and therefore there's no harm done. And as a former commercial photographer, and now as an attorney, that's, aside from being inaccurate,
right?
According to the law, it's offensive because
thank you.
That's not the standard. The standard is not. There's no harm done. The level that we used it, or the way that we used it, quite possibly helped your client. The issue is that there's this slow, steady creep toward, if you never caught us, there'd be no harm done. And what people don't understand is, commercial photographers, especially commercial photographers that are working in the environment now, that don't have an established body of film, or their work hasn't been widely disseminated. It all but eliminates the value of photographs when they're copied and disseminated, because once they get out without a credit and without compensation, without some way to link back to the photographer, the value of that photograph just dies.
Oh, yeah.
And that's the issue. And I think in the judge's defense, he is probably in tune with kind of the general consensus of the general public, which is, we live in a different world. It's different than it was 15 years ago. It's different than the internet somehow makes things different. And there's this area that wouldn't otherwise exist if it weren't for the internet, where individuals that aren't huge companies and doing millions of dollars of business can just trade in this practice of just small scale copying and dissemination of people's images.
And that is so inaccurate, because from personal experience, pre-internet days, I had my photographs ripped off. They'd appear in magazines, and all of a sudden I had friends all over, and I would get a menu from a restaurant and they're using one of my pictures, or an ad for a big holiday sale at a men's big boy shop using one of my, and things of that sort, with either directly using the photograph or just really doing horrible retouching, like scratching a beard onto somebody's face.
Right.
And this is before the internet. This is when people just saw pictures and grabbed them.
Right.
So it's nothing new at all. One thing I'm just curious about, there on the site that they found this Flickr photograph, there was a copyright notice, wasn't there? There
was.
Because there was if I'm not mistaken, there's a multiple choice about what levels of copyright.
That's right.
And it was clicked, and it was
right.
there.
Google's responsible for 90% of all searches in the world. Google has a notice directly below every single image that you source as a result of a search that says this image may be subject to copyright.
Right.
And it is unacceptable for someone to both, legally and otherwise, to search for something on Google and throw up their arms after they get caught and say, well, all I did was go to Google. What do you expect? I mean, the photographer's name wasn't watermarked, it wasn't watermarked across the image. That is something that unfortunately is becoming just much, much more acceptable. And photographic copyright is, to my knowledge, the only area of law and the only area of intellectual property where it's acceptable for someone that appropriates someone's photograph to use that type of defense, where you can just and I do believe people are honest and straightforward about it when they do break out the defense of, what's the harm? It's just this little image. There wasn't a watermark on it. I mean, that kind of standard, if you apply it to anything else, people would laugh you out of the room.
Can I ask a question though here? I mean, are we going to then ask judges and going forward the legal system then to define how we value photography? Because as you're kind of indicating, and even what Alan mentioned, pre-internet, the issue is, do we value an image that we find, or any image for that matter? And obviously when there's so many more images being created, and the value may be tending to go down, you kind of implied that the judge may have been just, going with the flow, or he may perhaps feel the same way that a lot of people feel, which is, okay, it's just an image, no harm, no foul, let's just go ahead and use it. So is it going to take some major case to just put a slam brakes on this whole idea and perhaps try to get the whole society to change the way they're thinking? Is that even possible?
I do think it's possible. Mm-hmm. I mean, photography it's easy to do that. It's easy for users that appropriate photographs to do that, because in most places, the only place that it exists is online. So it's not a print. It's not a sculpture that occupies a lobby. It's not
a magazine you bought on a stand. The pictures are being delivered to your phone daily.
That's right. And along with the notion that if you copy it, it's just going to go away. Like after you use it, kind of the potential harm is gone. But that's what makes photography different, is that when you're viewing it on a screen, it's somehow a little bit more detached than a physical object that occupies different space than a photograph does. And in my experience, just in the past couple of years, it matters. I mean, the Brammer case is a perfect example. I mean, the Brammer case is small potatoes. I mean, fundamentally, it is a small case, but there is a tremendous value, and my client didn't think twice about appealing it, and my firm didn't think twice about representing him in the appeal, is because it matters. It matters that we challenge the judges that have this notion that something so important and nuanced can be potentially be dismissed so easily. But it's also important because, things have changed, because prior to the Fourth Circuit overturning the case, opposing counsel used to throw that case in my face and say, well, you're familiar with Brammer, and so it's important to the IP world, specifically the photographic copyright world, is relatively small. And when certain attorneys, usually plaintiffs' attorneys, make a point of not folding, and that's not exactly the right word, but not just kind of going with the flow, it makes a difference. Because now, I go back to those same attorneys that threw the district court opinion in my face and say, look, this is it's not only been overturned, but it's been overturned by an appeals court. And not only has it been overturned, but the opinion it's detailed, it's very precise, and it addresses every single element, every single one of the four elements that make up the consideration of fair use very thoroughly.
Can we talk about that? Can you mention the four elements and how they applied in this case?
In general, the defendant in the case made a variation of what the vast majority of defendants make. The same kind of thing, the same kind of arguments. It's not a legal argument. It's everyone lumps all of their excuses into the fair use argument. It's fair use. Like, most people don't even bother going into the four elements. But so in this case, the appeals court ruled on all four of them. They ruled in favor, like demonstratively in our favor in all four of them, and gave very specific reasons why. And I know you're going to put me on the spot because I can't remember the order of the elements. But so one of them is the nature of the work. So whether or not it's a photograph of an empty kitchen table, or it's a photograph of the eclipse, that and kind of artfully done, and in a remote location that whose opportunity to capture an image only comes along once every 50 years. There's a difference. There's a difference between although there's a minimum level of originality that it's built into the copyright statute. There's a difference. There's a difference between a photograph of a white wall and a difference of the eclipse, in that there's the court considers the level of creativity, the level of work required, the artistic sensibility, the difficulty, all of those things.
How about the financial investment of a photographer? Do they consider that for somebody who, let's say, went to the other side of the world to get a photo?
Not explicitly,
right.
but it's inherent to that consideration. So that's part of it. And in this case, Mr. Brammer secured a rooftop location to take the photograph, specifically to take the photograph. He worked out the details of being there at a certain time and on private property at a certain location where he knew the light was going to be right, the time of day was going to be right, the sun was going to be setting at a certain time. He produced this image that is fairly artistic. I mean, it's not a snapshot. It's a photograph that uses timing and exposure, and
there was intent.
Absolutely.
It wasn't just, taking out the phone and going click.
Absolutely.
There's interpretation going on. It's not just a straight record. There was specific things going on in there that had to be controlled by the photographer.
Right. And that's part of the consideration. So the fourth element, which the Supreme Court has said is the most important, is the effect of the use on the market for the photographer. So how the appropriation of the work affects the market for that photo or that work of art for the author. And in this case, the great thing about photography is Mr. Brammer, like all of my clients, they're commercial photographers. They, these days, it hasn't always been the case, but these days, the business model is completely different from when it was 15 or 20 years ago. And I'm old enough and I was shooting long enough to know what the model was 20 years ago, which was you marketed your work to certain very predictable art buyers and editors in hopes of getting hired to shoot a job that they would then select their edits and license what they wanted. Now, I would say the vast majority of my clients, which I think is a fairly accurate snapshot of the industry, is that you shoot. They shoot as much as they possibly can. They pay for trips all over the world to photograph certain events. They act much more like stock shooters than they do assignment shooters. And the business model is that they use the free or very, very low cost platforms to display their work. Flickr is a perfect example. Some of my clients have been shooting for 40 years and are extremely accomplished, and they still use Flickr to display their work because it's cheap and everyone knows who it is, and Flickr kind of has they occupy this spot online where everyone knows where to go. Then the business model is much more of a stock-like business model where you produce the work, it's searchable, it's out there, and in theory, when buyers and editors, instead of starting from scratch and hiring somebody to shoot a shot that they have in their mind or they want to get, they're able to search this vast searchable database of existing images. So there's much more, and assignment photography still exists, but I would venture to say probably my clients on average, 50% of their business comes from reuse and licensing, where before I would argue it was probably 5 or 10%. So when someone like Violent Hughes takes a photograph and doesn't license it, that's directly affecting my client's bottom line, because that they rely on proper licensing of their work. They're far less reliant on assignment to assignment work to make up their bottom line.
Would it make any difference if it was someone who didn't define themselves as a photographer, or somebody who had a Flickr account but just put up the work that they happened to take and they had their day job? And would that make a difference, or should it make a difference?
It does make a difference, and Violent Hughes kind of attempted to make that point.
So in other words, if you are just a casual enthusiast posting your stuff on Flickr, your photograph has less value than somebody who took that same picture, who relies on every picture to make a buck.
No. And so that's how the new business model helps photographers of all types. There is a very high percentage of decent photographs that are in circulation and available and searchable that are taken by amateur photographers. And they happen to be wonderful photographs.
No doubt.
And the excuse or the rationalization of a defendant to argue, well, this person he or she's not even a commercial photographer. Like, what's the big deal? That's the exact wrong argument to make. It doesn't make any difference legally. The idea that someone could walk down the street and take someone's bicycle off their lawn and then rationalize by saying they don't really use the bicycle anyway, that they're missing the entire point.
They even keep it on the lawn. You can't ride on a lawn. They don't even know how to use it. Right, yeah. No,
but in this case, the defendant, from what I read, tried a few other techniques or a few other arguments, including the fact that well, I'll let you explain that.
So the big one, the big one in this case that caused so much dismay in the legal community was this argument that the defendant exercised good faith in their use of the photograph, which up to this point had never been recognized as a factor at all.
Right.
Well, I take that back. Bad faith had been used against a defendant. Good faith had never been used as an asset for a defendant. And the defendant tried to use the inverse of the bad faith argument that courts had recognized.
Can I ask real quick, did Violent Hughes have a lawyer that was, well versed in this? And was this a case that, lawyers decided to take up because it's a big case and let's try to fight it out, or it just happened to be,
Yes, they did.
They did. Okay.
And they had
so a nonprofit and a beginning out photographer hired two really big lawyers.
That's
or
right.
At least two big lawyers jumped in to help out. Yeah.
So Violent Hughes originally attempted to represent themselves. Mm-hmm. They're not permitted to do that because they're a business entity. So they hired is not the right word, but Kirkland and Ellis agreed to represent them pro bono. So at any given time, and the case is still active, by the way, because we're back in front of the district court. But at any given time, Kirkland and Ellis has employed three is probably maybe 4 employees pro bono on the case. So Kirkland and Ellis is a giant firm with tremendous resources. They know what they're doing, but this is something that is non-lawyers find, rightfully very, very frustrating, is that, otherwise very educated, very intelligent individuals can make these arguments that are just not viable. Yeah. And
so they tried to flip this to get to say to show they use good faith because, one, they're a nonprofit, they're helping out the photographer, they pulled the image down right away. This was their argument, more or less, right?
That's right. Yeah. And therefore they should not be liable. Right. And that there was no watermark or no credit embedded in the photograph.
But doesn't this all kind of boil down to this idea that we keep getting at, which is that how are we going to value photos? I mean, and they're basically saying, well, no harm was really done, and let's not worry about this person, this photographer. Let's just get on with it, and let the internet and the market kind of determine what's going on.
Yeah, and that's the battle. Yeah. That's the battle the we is my clients and my office and lots of other attorneys that do the same thing. There is a risk that slowly but surely, the legal framework around copyright and photographs is going to change. and that's a horrible thing. No other intellectual property discipline is subject to the same creep.
Is photography a little bit behind the other arts and the other industries in the sense that they've kind of gone through this already and they've established themselves and they've redefined the legal parameters, and photography is yet to do that?
Is it actually even different from arts? You just said, different photography, different than art. I think art in general has the same kind of parameters where a lot of people don't take it as seriously as, say, a Coke formula, or the ingredients of something that's a commercial product. I think a lot of people view photography and artwork as sort of like this vague, flaky thing done by vague, flaky people.
Certainly. That is certainly. I mean, I've experienced it. I experienced it when I was a photographer, and I experienced as an attorney even more, where it's individuals, otherwise smart, intelligent individuals, are very comfortable making that argument that art, and specifically photography, occupies this place where it's fun and useful, and it has a tremendous number of positive aspects to it, but it somehow doesn't rise to the level of protection.
Yeah,
and that's that's a disappointing part about things.
All right, so can we then kind of summarize? I mean, you're temporarily won the case. I'm not sure what's
you said it's still going on.
It's still going on.
It is. And
right.
what happens procedurally is that in the federal court system, the lowest level of court is the United States District Court. So everything starts there. If it's potentially a case can end there if there's no appeal. But we appealed the decision on the summary judgment stage, and it was essentially kicked back to the district judge or the district court. So the appeals court stepped in. They said, we disagree with the district court's ruling on the motion for summary judgment. You must change it. A circuit court essentially orders the district court to change their ruling, and then we start from where we were. So we still have a trial to prepare for if we're going to go forward. We still have jury instructions to prepare. We're at the tail end of the trial stage procedurally, but the case is not over. I would argue that the most important part of the case is over. The big picture is over. We have this opinion by the Court of Appeals, which is one level below the Supreme Court, that just unequivocally lays out why an argument or variation of the one that Violent Hughes uses is not only not fair use, but it's emphatically not fair use. And it's going to serve, unless something dramatic happens in the next couple of years, the case is going to serve as a source of hundreds and thousands of pleadings that basically stop
right.
any similar argument from. So
it's kind of a watershed. I mean, it may not be a big case in terms of the money values and whatnot, but it may be an important case. No,
it is.
Yeah,
it is absolutely.
At any point when Brammer first realized that his photograph was used without his permission, did he try to contact him and say, listen, you used my picture, there's a fee involved? Did he try to send them an invoice or establish a fee at all?
Always.
And they just said no. Is that what happened? So, okay.
That is the story of my life. I mean, my firm litigates plenty, and we litigate when it's necessary. But what a lot of non-attorneys and a lot of defendants don't realize is that and I'm speaking of my clients and my firm exclusively, but I would, my colleagues, we share the same approach in that nobody's goal is to spend our time litigating. I mean, there's a time and a place, but litigation is inherently inefficient, like dramatically inefficient. And this case is no different. This case is very typical. And we spent 18 months doing everything we could to try to get the company to engage in a substantive discussion about settling the case.
And how much did your client actually want for the use of this photograph? Which, in the great scheme of things, is really a small project. It was one picture out of many in a brochure that was a one shot. It's not like it's going to be all over the country for the next 10 years.
Our original, I think we came down a little bit, but when it's all said and done, I think our demand was $1,800, and they turned it down. And not only that, the $1,800 was based upon a history that my client had for licensing that image. So it wasn't even just
pie in the sky,
arbitrary.
yeah.
And they turned it down. And
why?
The argument that we hear all the time is, and this is, it makes my head hurt because this is something that my office deals with all the time, is that defendants say, well, we're really sorry, and you're right, but we just can't afford it. And my argument always is, number one, that's an equitable argument, which has nothing to do with the law. But my response is always, okay, well, let's have an equitable argument. My client is a solo practitioner who usually occupies a pretty low level on the totem pole compared to, an art buyer, a company, advertising agency. Now, I have plenty of clients that are extremely accomplished and occupy different space. But for the most part, commercial photographers that are solo practitioners, they are on the lower end of the power structure. When anybody appropriates their work without seeking permission or properly licensing the work, they cannot stay in business, period.
Right.
So if we want to engage in an equitable argument, then I'm all for it. Mm-hmm. And my argument is, when people steal my client's work, they're out of business. So it's plain and simple.
And I'm sorry, this kind of echoes the question that Jason had, and it gets to this idea of the good faith, bad faith, perhaps, because they could have gone to Getty and gotten an image, and they're not going to mess with Getty. But yet they went to Flickr, right? Where they maybe thought they could kind of just escape and grab this thing. So isn't that kind of showing a little bad faith to begin with? I mean,
yes.
And because they're not going to sue, or they're not going to go up against Getty, correct?
Yes.
Theoretically.
And that's the exact argument that the appeals court made. Mm-hmm. The exact the argument that the appeals court made was that, if anything, their actions were in bad faith, because everybody knows Getty. Everybody knows what Shutterstock is. And the idea that you can throw up your hands and say, well, I went to Flickr and I didn't consider any of these other options, is just, it's not a winning argument. Yeah. And the appeals court called them on it, rightly so, and said, there are thousands. And the argument that we make all the time as plaintiffs' attorneys is, take the picture yourself. If it's not a big deal, right. And the flip side to infringement, a lot of the flip side to infringement is, once infringers are found out, they're like, well, the photograph's not that. We could have used any photograph. That's typically, well, you see how there's a problem in that, right? But you didn't. You chose to do the quick. The quick fix or the lazy fix, and you decided to take someone's photograph where it matters.
One of the things I read in response to the Brammer case was, why don't we in order to really put an end to this, why don't we take these issues out of the civil court and make it a criminal case? Is that something that is considerable or realistic? And then would that really stop people from doing it if they're facing some sort of real heavy fee or even jail time?
Believe it or not, there is a criminal copyright statute now.
Okay.
You never hear of it. I've never even heard of it's never raised. And I look at it so infrequently. I've looked at it, but I look at it so infrequently that I don't know the exact parameters of it, but there is a criminal copyright statute. It involves, like the vast majority of criminal statutes, and unlike the civil version of the copyright infringement that is strict liability, the criminal version, and it's very narrow, has all of these mens rea parts to it, which is there are two parts of a statute, a criminal statute. There's actus reus, which means the actual actions, what you did, broke into somebody's house, hit somebody over the head, and then there's a mens rea aspect of it, which means your state of mind or your intent. the criminal copyright, the federal criminal copyright statute has both. So, and I believe, if I'm not mistaken, it has an even higher standard, which includes knowledge. So, a person to have violated a criminal copyright statute, you have to have knowledge that it's copyrighted. You have to know exactly what you're doing.
You have to really prove something.
You have to act. I think I forget what the standard is, but it's like reckless standard, and I know so little about the criminal statute just because you never hear about, and I'm not sure. I imagine, like any other criminal statute, it would have to be brought by some kind of prosecuting body. So it'd have to be brought by a U.S. attorney, like other criminal statutes need to be. So it would be out of the hands of an author of a photograph.
Right. I see. Yeah. Okay. So maybe just to wrap this section up, can you tell us a little bit about what you consider when you're looking at a case, whether you're going to take on that case from in the case of a copyright infringement or something? Is there, I mean, do you welcome all comers and or do you say, you know what, this one's not going to really work for you? And how do you play that out?
I don't have a hard and fast rule. I tend to still, I've been practicing for going on 7 years now, and I still kind of feel like I've got a little bit of a chip on my shoulder when it comes to
Well, I think we all like the fact that you were a photographer and you seem to really care about this.
Yeah, and that's not, it's not an act.
Yeah.
It's my clients, especially ones that are starting out, and I used to do this when I was still shooting. I used to feel the same way toward younger photographers that I had personal relationships with, about advising them to take stands when you need to take stands, to compromise when you need to compromise, and the same principle is at play here. I tend to give every case a chance. There are some cases that through a variety of factors aren't worth anybody's time, including an attorney's, because, contrary to what a lot of infringers claim, cases are very high maintenance. They take a lot of work. They take a lot of research. They take a lot of grunt work, just to make sure that we're on solid legal ground. We have our facts straight. We know who the proper entity is that should be compensating the plaintiff. And that said, I like taking on cases that might not be large cases, but in the end, I do my best to explain to my clients that there is a threshold. There is a threshold a minimum threshold that just needs to be met, because it's not going to be. You don't want my office or anybody else, any other attorney, working on a case that they're not going to be fully involved in because of certain, usually financial factors. You don't want that kind of representation because it doesn't do anybody any good. But that said, there are plenty of what I would consider modest cases that we prosecute and we get settlements out of it's well worth the time.
Yeah. This one's a little different though, because the settlement may not end up being worth it. I don't have any idea, but you looked at this case as almost like a potential home run, right? Like this is so at least the original decision that came down, you're like, hey, this needs to be challenged, right? And you took it on for that reason.
Yes. Yeah, and absolutely. Like you get to, this case is a perfect example. Most cases never even get close to litigation. Mm-hmm. So this case not only got to litigation, but we proceeded through litigation almost to trial. Right. Of the cases that I litigate, we almost never get to trial. We never even get close. The litigation threshold is usually the point where everyone comes together and says, hey, look, we need to, this is ridiculous. Right. If it's not the attorneys, it's the judge. The judge sometimes the judge will step in and say, gentlemen, we are not spending a day's worth of time in federal district court on a case like this. And it's a little disappointing, but my clients have no other option but to file in federal court. We don't have a state court option. So that's why we end up in federal court. So this case made it all the way to trial. And so the Brammer case was a perfect example of, we passed the point of no return like a week after we filed the case, because they lawyered up. It was clear that they weren't going away. Pro bono attorneys, a team of 3 attorneys, made it very clear that they were not going to settle the case. So at that point, you have the option of folding.
What do you think the reason was? I mean, why would they?
Yeah, that's wrong. Because what was the draw here? This is such a, I hate to say nothing case, but it's
right.
In the greatest scheme of things, it's pretty minor.
It is. And my 2 cents, there's a difference. There's a difference between a solo practitioner like myself, or even a small firm that has 2 or 3 attorneys, and a large firm. And Kirkland & Ellis is a large firm. Not only a large firm, but a very large firm. The difference is that cases like this case, in which they agreed to take, serve a very valuable purpose to their young attorneys, which is practice. So they get all this practice. They get real live litigation practice, and they break out all the stops. They file all these motions. They go through all. They read the statute 50 times. They consult with their more experienced attorneys that tell them to do this and tell them to do that. If I were to guess, that's what happened in this case. Any other case and any other experienced attorney would not dedicate the resources and the time that they did. And I think that's what happened here. And they're entitled to do that. And Violent Hughes is entitled to seek out pro bono help that is going to fight for them that way. But it wouldn't have happened otherwise if the dynamics were different.
We're going to take a short break and come back with more about copyright law with David Deal. Stay tuned.
We hope you're enjoying this edition of the B&H Photography Podcast. Send us a tweet at BHPhotoVideo, #BHPhotoPodcast.
Okay, we are back with David Deal. Just to get back into can you give an explanation of the Digital Millennium Copyright Act, also known as DMCA?
Sure. So the Digital Millennium Copyright Act is an addition to the Copyright Act. Specifically, it defines what is and what is not infringement based upon the would-be infringer's position. And that I mean, the key term in the Digital Millennium Copyright Act is whether or not an individual or an entity qualifies as a service provider. And that's the term that's the most important term in the DMCA. If you qualify as a service provider, then you are not liable for otherwise infringing upon people's
Can you give us an example
work.
of?
So a traditional service provider is a telecommunications company that handles the traffic and the digital files that represent photographs. So if you are, let's say, Verizon, before the DMCA, a point could be made technically that Verizon, every time they copied the digital version of a photograph or any other thing that's protected by copyright,
They're infringing. Yeah.
they are infringing.
Wow.
So
Okay.
the DMCA came along and defined what it was to be a service provider. Now, service provider, classic, obvious service providers are exactly what I described. Telecommunications companies that really serve as a conduit for this information. It's been expanded a little bit to include entities that don't handle the raw traffic and the raw digital information, but serve as a platform for others to post information on. So the classic example is Huffington Post. It is a platform set up for third parties to post content. The Digital Millennium Copyright Act protects Huffington Post because they have done a number of things required under the DMCA to be protected. The main one is they've registered an agent with the United States Copyright Office to handle takedown notices. from copyright holders. So although I haven't seen it exactly, I'm 100% certain that a HuffingtonPost.com website has a place on it that lists their copyright policy along with the name, address, telephone number, email, any way you want to get a hold of them, their agent that is registered with the U.S. Copyright Office. There are some other less obvious things that they need to do, but that's the main one. The other ones are that they can't be involved in any way. A service provider cannot be involved in any way in editing, selecting, designing the copyrighted material. So if they have their hands in things by selecting some images and not selecting, or selecting some content and not selecting other content, cropping images, copying some content that someone submitted to use for something else, then they're no longer protected. As long as they stay in this very narrow range or description of what the DMCA defines as a service provider, they're not liable for infringement. And this is it's an ongoing debate.
And other companies that you might not necessarily consider a service provider trying to become classified as a service provider?
Absolutely. Yeah. And they're, along with fair use, the DMCA is it's a distant second, but it's a clear second in terms of what I hear most often. There are, just because someone claims they're a service provider, and just because someone has a registered agent with the Copyright Office as well as posted on their website, does not mean they qualify as a service provider. A service provider has to has to satisfy all these other requirements too. The main ones I described. You can't, in kind of layman's terms, you cannot have a hand in what the content looks like and what it contains.
How long ago was this act put into place?
It's been within 20 years.
Okay.
So it was a response to, and the law evolves, the copyright law evolves just like any other kind of law. It evolved because of technological changes. And, I'm speculating, but I would guess that some attorneys and some photographers and some intellectual property rights holders made a case, made case or cases, before the DMCA was enacted that these companies were violating the Copyright Act. And, laws are typically the result of judges kind of going that direction, constituents complaining to their representatives or businesses complaining to their representatives that this is unfair. And in this case, the DMCA is completely appropriate, in my opinion.
Would somebody like Facebook, Instagram like to become a service provider, therefore, and be able to avoid all the issues of infringement and copyright, and then they'll follow that up with?
I bet they would.
Yeah, they are.
They are.
Yeah. But we can limit our discussion to the big ones. Instagram, Facebook, Pinterest. They're the major ones that technically they qualify as service providers. But with those companies, and there are other companies that fit the same description, there's so much more going on with their platform. At least from my perspective, Instagram, Pinterest, Facebook are the same as Napster. They provide this platform that it's not all but it permits the permissive infringement of, limited to photographs in this case, because it's primarily photographs in those cases, and to potentially oversimplify the situation, they throw their hands up. They're like, well, all we're doing is creating this platform, just like Napster did. All we're doing is creating this platform. We can't control what people do. They want to, if they don't do the due diligence and figure out whether or not they can download this music or upload this person's photograph, it's not our responsibility. We've complied. And in this case, the law is slowly but surely moving against them, in that they're like any case of negligence, which is a very, very broad, general legal term. In any negligence case, you have to and this is summarizing quite a bit, but it's negligence if you don't keep up with the market standard and the industry standard. If there is, for example, if there is software or hardware or anything that allows a company like Instagram or Pinterest or Facebook to do more than what they're currently doing, create some kind of system that flags potentially copyrighted material, they're responsible for installing it and using it.
And that technology
YouTube is a great example of a company that does that. You know, to a lot of people's dislike, there I don't know what they use, but I've heard stories from my clients as well as third parties. YouTube is remarkably quick at identifying potentially copyrighted material and flagging it. Instagram and Facebook and Pinterest do no such thing. And speaking just of my clients, those three companies are responsible for 95% of the headaches that my clients get, because it's a universe that once your image gets copied and disseminated on Instagram or Pinterest, you might as well kiss any value to that photograph goodbye.
It can be shared a zillion times all over the place.
Yeah,
It's like just throwing them out the window.
Let's jump
That's
right
right.
into this, because this is clearly something that we really want to talk about.
Yeah.
So can you kind of walk us through then, how does uploading an image to Instagram affect your copyright? Needless to say, how does it benefit you? How does it benefit them and anyone else out there?
And how do we protect our asses?
Right. So the current environment is a double-edged sword for photographers. I mean, it absolutely is the best and the worst of both worlds. There is no way that a photographer can prevent the dissemination of his or her work. Period. No watermark, no kind of metadata or anything that you can embed your photographs with is going to prevent someone from copying it. The upside to that is that might very well, in the big picture, be a positive thing. The downside to that is that for the general public, photographs are valueless. I mean, there's so many of them and they're so easy and it's so effortless to copy them that the value is next to nothing. Now, we all know that that's not true because there's a market, there's a very active market for commercial photography and commercial photographers still are able to make a living. And, but outside of that market, Instagram and Pinterest and Facebook serve as these super highways of infringement where there is little to no barrier to individuals, companies, anyone to just going out and taking copyrighted work and then just the universe just expands. The universe of that photograph expands just exponentially, and once that happens, there's no bringing it back. And I would venture to guess that. Let's say let's choose Instagram just because they're primarily a platform for photography. I would venture to guess that 90% of the images that are copied and posted on Instagram are copyrighted material, just plain and simple. Now, they might not all be actionable, because a non-commercial photographer who has a very small network on Instagram, you might want your friends to copy the photographs. You might want everyone in your group to make copies of them and add funny faces to them, whatever. But everywhere else, photographs of celebrities, news events, everything that any photograph of any kind of significance. I would venture to guess that 90% of those photographs that are being disseminated are violating somebody's copyright. And not only violating it, but there's no credit, there's no link, there's no evidence that there's a copyright holder at all. So once one entity makes the decision to do that, then everyone else has this implicit understanding that it's okay to do it.
There's a hole in the raft right there. That's what you got.
And so, the vast majority of my clients independently have communicated to me the current problem with those 3 platforms.
Do you post on Instagram?
I do. I have such a small network that it doesn't. No one sees my photographs. But I take it seriously, and as everyone should. I take it seriously, composing my photographs and making sure that I have a manageable group. But I certainly don't copy and post photographs that aren't mine. That I haven't taken.
Right.
And I'll give you a very real life example of how Instagram is single-handedly destroying photographers' livelihoods.
That's a pull quote. All right.
So I have a couple clients that are otherwise described as paparazzi. They live here in New York. Their business is to supply certain clients with photographs of certain people at certain times. That's the way it is. There's a huge market for it. They perform this very, very valuable role. People love to hate them, but they're the only reason they're in existence is because there's a demand for it. There's an overwhelming demand for their work, and they're really, really good photographers. For example, I've had cases where a client takes a photograph, uploads it to his stock agency's server, never been disseminated to the public, never been published, and someone breaks into the server, steals the photograph, and disseminates it on Instagram to different fan sites. And the fact pattern of my cases are that once it gets disseminated, it's a high quality photograph, it's someone that's in the news, then inevitably it ends up in the possession of the person who's the subject of the photograph. So it goes from fan sites that might have 100 followers or 1,000 followers to the subject, him or herself, that has millions of followers. Once that happens, the value of that photograph is zero permanently. So all of the would-be value, potential value of that photograph is gone and will never be recovered. And less extreme example is the photograph is published one place. It's published in a regular client by traditional means. It goes to their agency, who they have an agreement with to supply all their work to. That agency farms it out to some publication that publishes the work. There have been instances where people literally either screenshot the publication's website or actually screenshot the actual physical magazine or newspaper, then put it online. No credit, no link, no anything. And the important thing to remember is once an image gets into that territory, everybody else thinks that it's okay to copy. Everybody else thinks it's not credited, there's no link, and it's on this individual's website that has millions of followers and occupies a pretty good spot, in the public view. Why would it not be okay for me to copy it? I'm just a small player.
And all these people have since picked up on it and made use of it. Are they liable in any way, or are they just free and clear at
Technically,
this point?
yes. Copyright infringement is strict liability. So if you copy, you don't even have to use it. If you make a copy without proper license or permission, you have violated the copyright statute.
Regardless of how many generations it's gone through of not being.
Absolutely.
Okay. So you have a lot of guilty people out there.
Yes. And now the vast majority of these cases are not viable.
Sure.
Just because, for numerous reasons. And this happens, the dynamic that you just explained happens all the time with big companies. The big companies are second or third or fourth or 10th down the row. And they're like, well, how are we supposed to know? Happens all the time. And that's just simply not a defense.
And, but just to jump back a little bit, let's say for a photographer, more or less like ourselves, who small following on Instagram, but Instagram can serve us a little bit because we can get our work out there and someone may bounce back, whether it's just feedback or a small job or whatnot. Instagram, and I guess Facebook owns Instagram, so they don't own anything. They're claiming that they're just a service provider, right? So they don't have any copyright. They don't own anything on this. And it comes down to us whether we want to play the game, right? Whether we want to have the double-edged sword, in our back, where we may get a benefit out of it, but ultimately, if something happens, we may not have, the photo may lose its value. That's kind of where we're at, and to some degree, we're all complicit then, right? Because we're willing to play this game, and where will the stopping point be? I mean, and I'm going to jump on what Jason just asked me. Is it going to be a technological thing? Is it going to be a money thing? I mean, if YouTube can do it, why can't Instagram, find an algorithm to stop this?
That's the question. Mm-hmm. The question is, we're certainly not at a point where everyone feels comfortable. Everyone feels inherently uncomfortable now. Yeah. Everybody does. The photographers do. Instagram does. All of the third parties that kind of weighed in. Everyone feels uncomfortable because we're not in a place where everyone understands and everyone considers fair. Images are remarkably easy to detect online. For example, a solution might very well be Instagram to develop some kind of system where they create a database of images that people have flagged, authors have flagged, and that it's permanently on this list. From that point on, it's permanently on a list where it needs to be it needs to be cross-checked. Any incoming information needs to be cross-checked against that database. Or, placing a small amount of responsibility on the artist or the photographer to supply a company like Instagram with low-res versions of all the photographs that are their copyright and that they don't want disseminated on Instagram. Those strike me as very easy, low-cost solutions that would solve the vast majority of the. I mean, I suppose it impacts commercial photographers the most. You'd have to do a little bit of work. You'd have to do a little bit of work developing or at least editing, your top 10% of photographs that you absolutely positively do not want to be copied and disseminated. But there would be no stopping, amateur photographers from doing the same thing. If you want to invest that little bit of time, then it would effectively shift the burden to Instagram that would now be in possession of that information and the technology to detect it. It would change the balance of the way things are right now for the better.
So now, how many pictures a day offhand do you know would Instagram post on an average day? Do you have a number in mind?
I have no idea.
Let's just say
millions.
Let's get millions. Okay, now there are a number of organizations or companies, whatever you want to call them. One of them would be, I think it's Photo Rights, where I belong with them. You send them for X amount of dollars, you register your photographs, and they basically keep an eye out. And every few weeks, I get a report. Hey, we found this, and quite often, it's stuff I posted years ago. They're still actually digging it up. So this technology exists.
It exists.
Now, you take that same technology and you have Instagram use it. They have a lot of work they're going through every single day, and then they have to first verify. Now, a lot of this could be automated, but ultimately, somebody has to sit there and look and decide yes or no, do we pursue this? Which alone would be a huge expense. Is that one of the reasons why they don't want to bother with it?
I don't know. I mean, I don't know, but I would venture to guess that, they're gonna get away, or at least try to get away with the least possible involvement. But I do think the time is going to come, and the law and the consensus is moving in the direction where they're going to be required to do more.
Would it be fair to say that it's actually a better idea for them right now, for a number of reasons, not to employ these technologies? Because once you do it, you're accepting responsibility. That's right. Right now, it's still a nebulous thing.
And this is going back to the industry standard for negligence. That's why it's so complicated sometimes. So what's the industry standard? I mean, the industry standard the classic example in law school is, a shipping company that is 30 years behind the time in navigational equipment and, has a huge tanker run aground. They're negligent because everybody else is employing this advanced navigational system that's cheap, easy, and works really well. If you don't do that, then you're in negligence territory. And I think we're slowly but surely, those companies are moving into that territory where all these other companies can do it. All these other companies can, like image rights, and I happen to work with Pixie, who is another a company that does a terrific service for photographers. In their interface is sophisticated and easy to use and user friendly, and kind of puts the onus on the photographer to kind of pick and choose, which things they think are viable or not. It's not complicated. And if Instagram refuses, or Facebook or Pinterest refuses to engage in that type of technology, voluntarily, they're eventually going to be forced to do it.
Let me jump in here really quick, just because we're running a lot longer than I thought, and there's a ton of stuff I think we'd all like to ask. But
I told you just stick to yes or no answers, but no, you keep talking.
maybe you can just throw out maybe a quick checklist that we can have our listeners, to our listeners, to what they should do to protect themselves, and maybe just best practices, for once they push click, going forward. And then
there are two things. Mm-hmm. There are two things that are just disproportionately worth every photographer's time. Mm-hmm. The first one is timely register all of your photographs. Mm-hmm. That is the most efficient, best thing you can do. If you are a commercial photographer, or you are concerned about the infringement of your work, timely registering your work is an absolute necessity. And there are a number of ways you can accomplish that under the copyright statute. The easiest one is you register it within 3 months of first publication. That's the easiest way to do it. Kind of the backside of it is you can register a work within 1 month of infringement. Mm-hmm. So it's a little trickier, because you have to know when the infringement took place. Right. There's no discovery.
Does the work have to be published? I mean, can you just register an image you took that hasn't been published yet?
Absolutely. Yeah. So if you register a work prior to publication, it's automatically timely registered.
Right. That's the best way to do it.
Best way to do it. And my clients who are the best at timely registering their work register their work in groups every 3 months. So you cannot lose.
Now, if I'm not mistaken, it's like about $50-something for up to 750 images or something like that. It's not expensive.
It's not expensive, and I thought it was 35 and might be 50.
It could be. I think 35 it might be. Yeah.
It's remarkably inexpensive, and now although they reduced the number of images that you can register as a group, I believe it's still in the neighborhood. It's a couple hundred. I think it might even be as high as 750. It's well worth
the
time
trick is
and
to
effort.
Just cherry pick your image. Don't just take
Don't
download upload your memory card and go all of them.
And the copyright statute has a giant fork in the road. So one side is actual damages and the other side is statutory damages. Actual damages is for images that are not timely registered. Statutory damages are for timely registered images. If an infringement is determined to be willful on the part of the infringer, then you're eligible for up to $150,000 per incident. So those are really big numbers that come with very little effort. And speaking as a plaintiff's attorney, the option of litigating with statutory damages and fees, by the way, that come with it, we're in completely different territory than actual damages. So actual damages, you're limited to proving with no level of speculation what your actual damages are.
So the truth of earning a living in photography is to putting out your stuff there well in advance and hoping you get ripped off many times.
Find a good lawyer. Don't forget about that part. Yeah. So what was the other one? There was two.
So the other one is, and this is, my clients have like a very wide range of views on the subject matter, and it concerns attaching your copyright or watermark to the image. Lots of photographers don't like to do that because it changes the image. Mm-hmm. What I found is what is kind of a happy medium is including a watermark, but one that is very, very faint. It's there, it's obvious, it's not in the corner. It's either diagonal or across, that is so light and is at 10% or 20%, that the image can't be exploited without someone noticing it, and it's very difficult to remove. The only problem with putting a copyright notice in a corner is that it can be easily cropped out. And that happens all the time. All the time. So those two things, there are other things you can do, but those two things, if you're going to pick and choose what's the most efficient, those two things dwarf everything else.
And what's the value of writing copyright in your metadata? Is there any value to that at all?
There is. The value is if there is existing metadata with a copyright properly credited, you get the assumption that, assumption is not the right word, but the burden shifts concerning willfulness.
Gotcha.
So if it's there and it's easily accessible and it says clearly copyright whomever, then the burden shifts to the defendant in the infringement to prove that the infringement was not willful. Otherwise it remains with the plaintiff.
Gotcha.
Okay. I mean, like I said, there's a lot we could talk about. A lot of questions we have left on the table, but it's going to have to wait till another time. Quick question. What are you shooting right now?
Not a whole lot. I shoot a lot with my phone.
Okay.
And 5 years ago, I would never, ever have admitted that, but I shoot a lot with my phone.
Oh, you're not alone. That's. I mean, in the past few days, we did a lot of recording, and that topic came up a lot.
I shoot with my 4x. I still have a 4x5.
Oh, cool.
And I still have a Rolly, but I don't shoot a lot.
Really?
Yeah, I don't shoot a lot. I shoot portraits of my kids with my 4x5.
All right. Well, there you go. That's good. Yeah. So what kind of digital back do you have in your 4x5?
Oh, I don't shoot. No, I don't have any. and I shoot slides too. I shoot 4x5 slides.
Wow. Okay.
That when you get them, I mean, I shot digital slides for like 15 years, and I got hired specifically because I shot that way, and then that went away. But there was a long period of time where I got hired because I shot 4x5 slides because they look different.
It's gorgeous.
Gorgeous.
Yeah.
When you get it right, you get it right. And it just like, you cannot believe it can look that good.
Yeah.
But even black and white too.
Is there kind of a clear moment when a photographer should reach out to a lawyer and should kind of pursue a case? I mean, is it about the size of the infringer, the company that infringes? Is it about how much you can make? Is it about, unless you want to make a stand, of course, I mean, is there?
Yeah. I mean, I feel calls from all different types of people. And there's really no really, I mean, I would say every case is worth pursuing at a base level. Right? Absolutely. Yeah. And I make that clear to a lot of clients too, that, these cases, they're not, they might not be huge and they might not be, the first thing I explain to my clients is that even the upper end of my clients, we're not talking about a windfall. It just, things like that, they don't exist. Right. Like I've had plenty of cases and I've had plenty of very good results, but a photographer who is not versed in the process is under the impression that all they have to do is catch somebody using their work and they're going to, and it just doesn't exist that way. Yeah. It doesn't exist that way for so many reasons. But that being said, there are cases, even small scale, that are worth pursuing, even at a very low level. Even if you never plan to litigate, they're at the base level, they serve a purpose to put that
it's another brick in the wall.
That's right. We're not going to just kind of roll over.
Right. And you generally implied that you feel that we are on a path moving forward where photographers will be more protected, where images will have a little bit more protection, and we won't see kind of this Wild West of infringement that we are seeing or have been seeing for the past 10 years. Do you feel that we're generally moving that way?
I do.
Slowly but surely. Yeah.
I mean, it's difficult because I'll use my children as an example. Their universe and their perspective is completely different from ours, in that they have never had a sense of ownership in specifically their photographs. I mean, it's different. They don't treat them the same way. They treat them as just these interchangeable parts that are meant to be shared, and that inherently is difficult to square with the other end of the spectrum, where these legitimate extremely talented, longtime commercial photographers are fighting on the same battlefield. So it's difficult, but the copyright laws favor photographers.
As long as you don't get that judge in the Virginia District Court, right?
That's right.
So, well, after the case, we'll ask you to come back, or we'll do a Skype or something like that, maybe.
Awesome,
David. It's been quite informative. We covered more territory than I even think we expected to, and got more information than we ever thought we'd see. And it's a big subject, to say the least. If people want to see, check out your website, or maybe look at your photographs, where should they be going?
My firm website is daviddeal.com, and it's all one word. It's DAVIDDEAL.com.
Okay, all right. And again, it's
and your Instagram account?
Yeah, Instagram.
it's private.
Is there an advantage in making your account private? I mean, in this sense, in the legal sense?
I don't know. My network is so small that it probably doesn't make a difference either way.
Right.
Not after this show. All right. Anyway, David, it's terrific. Thank you so much for joining us today and being here in the studio. If you are not a subscriber to the B&H Photography Podcast, your time has come. All you have to do is head over to Apple Podcasts, Google Podcasts, Stitcher Overcast, or Spotify. You can always find us on the B&H Explorer website and the ever-growing B&H Photography Podcast Facebook group page, and tell them that Al sent you. For now, on behalf of Jason, John, and myself, thank you so much for joining us today.